You are welcome to the aspirants of the All India Bar Examination, Cohort 17, 2023. Karibu sana, welcome in Kiswahili. Now, shooting list. 31st question. What are the 5 laws in Islam? The 5 pillars, which is the correct sequence. A. The declaration, prayer, that is salah, almsgiving, zakat, fasting, sawm, faith, shahada, and pilgrimage, hajj. B. Shahada, salah, sawm, and hajj. C. Shahada, salah, zakat, and hajj. D. Shahada, hajj, salah, zakat, and sawm. Which is the proper sequence of the
Option
5
A, sir.
pillars?
Option A, sir.
Number 1, salah. Number 2, zakat. Number 3, sawm. Number 4, shahada. Number 5, hajj. That is the right sequence. Are you sure?
Yes, sir.
No.
C is the right
Salah
answer,
you
sir.
can have only at the time when you have the faith. If no faith, no salah.
Sir, C is right answer, sir.
C is the right answer. Because first you have the faith, that is shahada. And next you can say salah. Next almsgiving, zakat. Next sawm, fasting. And the last one is hajj. So the right answer for the 31st question is C. Is it clear?
Yes, sir.
Yes. Now anyone can unmute the 32nd question. Read in sonorous voice. Hurry up. Why you are taking so much time?
Bismillah means Arabic language. A. Agreement. B. Temporary. C. Pleasure. D. Desire. Temporary B is the right answer, sir.
I know that because muta means temporary marriage. Definitely that you will say the same thing. So intentionally I kept it. WRONG.
C is right answer, sir. Pleasure.
C is the right answer. It is a pleasure. Arabic language muta means it is a pleasure. That is the right answer. Okay, 33 question. Which option is the correct option among the 4 options? A. Muta is Islamic law, a temporary marriage that is contract for a limited or a fixed period and involves the payment of money to the male partner. B. Muta is Islamic law, a temporary marriage that is contracted for a limited or a fixed period and involves the payment of money to the female partner. C. Muta, that is Arabic pleasure, in Islamic law, a temporary marriage that is agreed for a limited or a fixed period and involves the payment of money to the female partner. D. Muta, that is Arabic pleasure, in Islamic law, a temporary marriage that is contracted for a partial or a fixed period, involves the payment of money to the female partner. Among the 4 options, which is the appropriate and correct option?
Sir. D is right answer.
Say again.
D is right answer, sir.
The last one, option D. D for Delhi.
Option D. Yes, sir. Right.
WRONG.
Option B, sir.
Option B is the right answer. If you closely watch, you know it. The reason is, you say D. Why D is wrong answer? Muta in Islamic law, a temporary marriage that is contract for partial. It is not partial. It is a limited. Hence, D is the wrong answer. And A is the wrong answer because it is a money to the female partner, not male partner. Is it clear?
Yes, sir.
And
Yes,
C, Muta is Islamic, a temporary marriage that is agreed for a not agreed, contracted. Is it clear?
Yes, sir.
Then B is the right answer. So now 34th question. Anyone can unmute and read? Quick.
Mahar within the parents alternately transliterated as
Transliterated as a mahar. Continue.
Mahar, Meher or Mehrich is a contract some Muslims enter into upon marriage. In Islamic law, it is a gift or contribution made by the husband to his wife to be for her exclusive dash as a mark of respect for the bride and as recognition of her independence. Option A, money. Option B, property. Option C, things. Option D, assets.
Option
Money,
A,
sir.
sir. Money.
Option A, money.
WRONG.
Sir, option C, things.
WRONG.
Sir, option D, yes, sir.
WRONG.
sir.
Option B, property.
Option B is the right answer. Is a property. Either property in the form of money, property in the form of thing, property in the form of assets, property in the form of mobile or immobile. Yes, please mute. Mute. I am getting the sound. When you speak, you have to open it. Kannaya, you stop your video because audio
Okay,
here
sir.
is not there.
Okay, sir. Okay, sir.
And Lakshman, I could not see your mute. I am getting the sound still. Lakshman, yes, please mute. Thank you very much. Yes, when you speak, when the highest is there, take the screenshot. Okay, now, next question, 35th question. Nikah halal. Nikah halala, also known as dash marriage. A. Tahani. B. Tahrik. C. Tahleel. D. Tahleek. Out of the A, B, C, D.
Sir, Tahrir.
Option B, Tariq.
Repeat.
Option B, Tahrir.
WRONG.
T is right, sir.
Repeat.
Option C, option C, sir.
If you say option D, Tahleek, WRONG.
Option C, sir.
B for
Option
profit.
C, Tahleel is the right answer. I repeat.
Yes, sir.
Option C, yeah, mute. Once you give the answer, mute. C, Tahleel is the right answer. Okay, now 36th question. Sexual, lustful, and affectionate acts such as dash are haram in Islam before marriage because these are considered portion of zina which lead to the actual zina itself. Number 1, caressing. Number 2, kissing. Number 3, touching. Number 4, staring. Here options I have given. A, please mute. Once I finish it, then I can ask you to shoot. Option A, 1 plus 2. Option B, 1 plus 2 plus 3. Option C, 2 plus 3 plus 4. Option D, 1 plus 2 plus 4. Now shoot.
Option B,
1
sir.
plus 2 plus
1
3.
plus 2 plus 3.
If you say option B, wrong answer.
Option D, sir.
Option D, if you say 1 plus 2 plus 4, wrong answer.
Sir, option C, 2 plus 3 plus 4.
Option C, 2 plus 3 plus 4 is the right answer for the 36th question. Even kissing, touching, staring, I concocted, fabricated kerosene. These are the three are there which covers everything. Which covers everything. Okay, 37th question. Match the following. And here I have given at a part A side unspecified dower, 2 specified dower, 3 prompt dower, 4 deferred dower. In the part B, let's say the terminology in Arabic. Muajjal, Muwajjal Mahar, Maharul Misal, and Maharul Musamma. Now, options are given here. A, 1B, 2C, 3D, 4A. B, 1C, 2D, 3A, 4B. C, 1D, 2B, 3D, 4A. D, 1A, 2D, 3C, 4B. Which is the correct answer.
Option A is correct.
If you say option A, WRONG.
Sir, option C.
If you say option C, WRONG.
D is right, sir.
D is right answer, sir.
B is the right answer. That is 1C, 2D, 3A, 4B is the right answer. Here feedback I am giving you. Unspecified word Maharul Misal. Specified word Maharul Musamma. Prompt word Muajjal. Deferred word Muvajjal Mahar. That is Muajjal, Muvajjal. The last one V sound and A sound is prompt. Among the supplementary question, among the 4 types of the mahar, which one is Prophet Muhammad say the best mahar? Supplementary question.
Specified dower is
Wrong. Which is the best mahar to get married the Muslim woman or Muslim girl?
unspecified dower.
Deferred, sir.
Wrong.
Unspecified dower, sir.
Wrong.
Prompt, sir.
Prompt dowry is always a good mojal. Spot payment, then nikah, then consummation. That is the right way. So 38th question. The then government had passed the legislation termed as dash and aimed to overturn the Shabano judgment of the Supreme Court. And here given the option A, the Muslim women's within parenthesis production of right on divorce 1985. B, the Muslim women production of right in divorce within parenthesis 1986. Muslim women within parenthesis production of rights and divorce 1985. The Muslim women production of right on divorce 1986. Which one is the
Option D. Option D.
D is right
D
answer.
is right answer, sir.
The Muslim woman parenthesis protection of rights and divorce 1986.
yes? Why the A is wrong answer? Because tell me.
C85, sir.
Why is see the Shabano case decided in the which year?
86.
85, sir.
85. After 85, Congress government made the act. Please mute, Venkat Reddy. When you speak, you can unmute. Lakshman, please mute. Because I am getting the sound here. That's the reason. So, in 1986, they made the amendment to this act, a new act. And a supplementary question. Who challenged this act, 1986? Supplementary question. There are 5 acts are very famous acts. 5 case laws are very famous case laws. Number 1, Shabano case law. Number 2, Daniel Latif case law. Number 3, Sahra Bano case law. Number 4, I think it is a Uday Kumar case law.
Saira Banu, sir.
No. You see that it is a case law, Sahabano case law only. It is decided. So 1986 they made the amendment for this one to curb it. Daniel Latif challenged it 1986. Daniel Latif case law. Okay, we'll come across now. 39th question. I think I framed the question already on that one, but I give the answer now only. The petitioner denied having been divorced. One of the major points of conflict was that is a divorce valid if it is not directly communicated to the wife? Within parentheses, in this case, the husband said to have dissolved the marriage by means of the triple talaq in presence of the neighbors, and the said divorce communicated to the appellant become effective from the date of filing the written statement by the husband in proceedings was observed in the case of, which case law here? See, I have given the 4 cases. I missed the Shabano case. Number 1, Shamim Ara versus State of UP. Number B, that is B, Shayara Bano versus Union of India and others. C, Daniel Latif and other versus Union of India. D, Ahmed Women Action Group versus Union of India.
Option D, Ahmed Women Action Group.
WRONG.
Option B, sir.
Daniel Latif
Shayara
and another
Bano.
versus Union of India is correct, sir.
Sir, A is right answer.
A is the right answer. Mute. A is the right answer. Shamim Ara versus State of VP, it is decided. And Sayara Bano, triple talaq is biddat. It is against the provisions of the Article 14, 19, 20. And Daniel Latif, he challenged the 1986 Act, but he failed because it is as per the constitutional provisions. And Ahmed and Women Action Group also, it is the maintenance case. Okay, 40th question. 4 months and 10 days, that's about the 130 days, given or take a leap year or a third of year, the time widow is meant to mourn for her husbands in Islam, dash. At what time? In which situation? A, in case of divorce. B, mutual divorce. C, khula. D, in case of her husband death.
D, sir. Option D in case of.
It's very easy. I don't know. I thought to make it tough, but anyway, I made it simple. Okay, doesn't matter. It's the 4 months and 10 days is in the case of her husband's death. That is the iddat period should be followed. Now next 41st question. The Indian Christian Marriage Act 1872 contains dash how many sections and how many parts and how many schedules. And here I have given the A 8894, B 8984, C 8874, D 8884.
A.
Wrong.
Option B, sir.
Option B, if you say option B, WRONG.
Option D,
D is right answer, sir.
option D is right.
D is the right answer. D is the right answer. Now mute. D is the right answer. That is 88, 8 and 4. Because sections are 88, parts are 8, schedules are 4. Is it clear? Yes. Say yes, then mute.
Yes, sir.
Yes, sir.
42nd question. In the case of Dash, All India Reporter 1945, the Madras High Court clarified that Section 88 of the Act shall cover the prohibition based on the blood relations and affinity. In which case law it is? A. V.H. Lopez versus E.J. Lopez. B. Mr. Chandramani Dubey and other versus Ramashankar Dubey and others. C. Gnanash Soundari versus Nallat Thambi and others. And D. Ganamuttu Udayar and others versus Anthony and others.
B is the right answer, sir. Mrs. Chandramani Dubey and
Option
another
C.
versus Ram Shankar Dubey and others.
If you say the Chandramani Dubey, it is a wrong answer.
D, sir.
Option
Sir,
C,
D is
sir.
right answer.
D, sir.
D, if you say
Option
D,
D.
if you say D, it is a wrong answer. Gnana Soundari versus Nalla Tambi and others. In that case, it is decided. Tambi is no, you can make it Tambi. Tambi comes only to the Madras people. Am I right?
Yes, sir.
Okay, now 43rd question. In the case where the marriage is being solemnized by a minister of the religion or a marriage registrar, the act requires a certain procedural formalities to be followed, such as number 1, the bride and bridegroom should show the required age to solemnize the marriage. 2, giving notice of intended marriage. 3, publication of notice followed by the declaration by the parties. 4, registration of marriage. So option which I have given is, I will pull down to the next page. It is gone. Okay. Option A, 1 plus 3. Option B, 1 plus 2 plus 3. Option C, 1 plus 3 plus 4. Option D, 2 plus 3 plus 4. In this, which option is the right option?
1 plus 3 plus 4.
1 plus
Option
3
B.
plus 4. WRONG.
1 plus 2 plus 3.
WRONG. See, I asked the procedure. In case where the marriage is being solemnized by the minister of the religion or the marriage register, the act requires the procedural formalities. Which is the procedural formalities among the 1, 2, 3, 4? You can easily
1,
make
2,
it
and
out.
4.
Yes?
1, 2, and 4, sir.
Bride and bridegroom, the marriage age is not procedure, it is a substantial thing. Procedure is giving a notice of intended marriage, publication of notice followed by the declaration of by parties, and a registration of marriage. These are the procedures. The age is validity of the marriage, that essentials, that is not a procedure. Is it clear?
Yes, sir.
So, right answer is
2 plus 3 plus 4.
2 plus
D.
2
3
plus
plus
3
4.
plus 4, sir.
that the D is 2 plus 3 plus 4. I intentionally prepared this thing because I know that I want to know whether you make the distinction between a substantial law and procedural law. 44th question. Dash of the Act provides that Christian marriage can be solemnized only between 6 a.m. to 6 p.m. This is a procedure, except the following cases where it is given in the which section of the Christian Marriage Act? A. Section 9,
9, sir.
B. Section 10, C. Section 10 capital A, D. Section 10 capital B. Shoot.
Section 9, sir.
WRONG. If you say Section 9, WRONG.
C is the right answer, sir. Section 10, capital A.
WRONG.
Sir, only section 10, option B.
Only Section 10. Option B, only Section 10. It specifies that marriage solemnized between the 6 a.m. and 7 p.m. Subsidiary question. If the distance from the marriage to the church is more than 3 kilometers, at the time it can be solemnized in any other place also. If you read the Act, it will give the clear picture. Anyway, 45th question. The Indian Divorce Act 1869 only provides a ground on which marriage are void, but provides no ground on which a marriage is dash. A. Irregular. B. Voidable. C. Invalid. D. Illegal.
Invalid.
WRONG.
Irregular, sir.
Irregular.
WRONG.
Option B, voidable.
It's a voidable.
Yes.
Irregular marriages comes in the Muslim law. Example, a Muslim man can have the 4 at a time wives. If you could have the fifth one when the fours are allowed, then it becomes a irregular marriage. Unless until you divorce one. Okay.
Okay, sir.
Okay. Another supplementary question, though not connected to you. What is that movie and where? Hindi movie. And some shots are picturized in Hyderabad Arts College. And there, if you want to marry the same woman to whom you divorced, that woman should have to marry the another man, have the consummation, again take the divorce. At that instance only, the first husband can marry the divorced wife. What is that movie name? Supplementary question.
Nikah.
It is a nikah.
Nikah.
Yes, I appreciate. So now, 47th question. Okay, no, 46th I did not read total, I believe. Yeah, the husband or wife can obtain the degree judicial separation on the ground of adultery or cruelty or desertion without reasonable excuse for 2 years or more, and such a decree will have the effect of divorce under dash. Which act? A. The Hindu Marriage Act. B. Indian Succession Act. C. The Special Marriage Act. D. The Indian Divorce Act.
Option B, Indian Succession Act.
Indian
Wrong.
Divorce Act, sir.
Hindu Marriage Act.
Hindu Marriage Act. Wrong.
Sir, Indian Divorce Act.
This is the D. The Indian Divorce Act is the right answer for the 46th question. The Indian Divorce Act is the right answer. Then 47th question, and here part A, I made the different people, and part B, I made the acts. Number 1, divorce among Christians. 2, Muslims. 3, Parsis. And 4, the civil and inter-community marriage. In the part B, acts, the Special Marriage Act. B, Parsi Marriage and Divorce Act. C, Dissolution of Muslim Marriage Act. And D, the Indian Divorce Act. Now I made the options here, and you have seen the part A and part B. The option which I have given here is 1B, 2C, 3A, 4D, 1C, 2B, 3A, 4D, C, 1D, 2C, 3B, 4A, D, 1C, 2D, 3A, 4B. And shoot which is the proper.
C is right.
Option C.
C is right answer.
Option C.
is right
2C, 3B, 4.
Option C
is
is the
right
right answer. That is 1D,
Option A.
2C, 3B, 4A is the right answer. I repeat, option C is the right answer. 1D, 2C, 3B, 4A. Here a feedback. Divorce among the Christians, Indian Divorce Act. Muslims, Dissolution of Muslim Marriage Act. Parsis, Parsi Marriage and Divorce Act. The civil and inter-community marriages, irrespective of the religion, caste, creed, it is the Special Marriage Act. Is it clear?
Yes, sir.
Yes, sir.
Now, Dharmendra and Hema Malini, which type of marriage they conducted?
Muslim, sir.
It is a Muslim marriage. Now, Dilip Kumar and Saira Banu.
It's a Hindu marriage.
Special
No,
marriage.
it's a Muslim marriage.
Oh, it's a Muslim marriage.
Lion Pathodi, Mansur Ali Khan Pathodi and Sharmila Tagore.
Muslim, sir.
Muslim marriage. Now, Sharmila Tagore's son or Pathodi's son, what is his name?
Saif Ali Khan.
Saif Ali Khan married to the
Amrita
Kareena
Singh.
Kapoor. Which type of marriage it
Kareena
is?
Kapoor.
Muslim marriage. Special marriage act. Sir.
It is a Special Marriage Act, not a Muslim Marriage Act. It is a Special Marriage Act. Yes, it is a supplementary question. I don't think such a question will be asked, but anyway, the reference is there, and hence I made it. 48th question. Petition by wife. Any wife can present a petition to the district court or the high court for a dissolution of marriage. The wife can file such a petition under any of the following circumstances, which is one is odd man out, not relevant. A. If her husband has exchanged his profession of Christianity for the profession of such other religion. B. if the husband went through a form of marriage with another woman, C, if her husband has been guilty of incestuous adultery since the solemnization of marriage, D, in case of bigamy and incest.
Option B, if a husband went through
B
a
is
form of
wrong.
marriage with another woman.
B is right answer, sir. Option B is right.
No.
C is right answer, sir.
See,
Option A, sir.
actually,
Option A, sir.
actually, I framed it because I did not see the incestuous adultery there. Okay. Here, which is not the odd man out, which is the correct answer for among them. So I have to give the options, not odd man out. Because
Option A, sir.
here,
Option A.
incestuous is there. Incestuous is there. Again, the incest is there. But incestuous adultery or bigamy or incest. But actually, it is here. It is not the incest. It is the adultery. It is adultery. But here, incestuous adultery is there. That means it is included. So my question framing should be, which one is the right answer, not odd man out. Which one is the correct answer? Sorry. Which one is the correct answer? That is the... where it is gone? Yeah, here. Which one is the correct answer is the answer. So option A, I have to make it out is, which one is the correct option. So now A, here I should put it 1, 2, 3, 4. So A, 1 plus 2, B, 1 plus 3, C, 1 plus 2 plus 3, D, 1 plus 2 plus 3 plus 4. Now you tell me.
Sir,
Yes?
Sir,
1 plus
2
2
plus
plus
3.
3, sir.
All the things. Here if I put the option here I put that A, for instance here, A, 1 plus 2, definitely it is there. Then B, 1 plus 2 plus 3. Then C, 2 plus 3 plus 4. Then D,
1 plus 2 plus 3 plus 4, right, sir?
then that is the which I am giving here. Yes, this is the right answer. 1 plus 2 plus
3 plus 4 is right
plus
answer.
4 is the right answer because everything is the right answer there. Of course, the feedback now we can remove it. Yes, 49th question. Anyone can unmute and read 49th question? Anyone can unmute and read 49th question?
Petition by wife. Any wife can present a petition to the district court or the high court for dissolution of marriage. The wife can file such a
Yeah.
petition under any of the following circumstances. Which one is the odd man out? Option A, in case of marriage with another woman with adultery. Option B, in case of rape, sodomy, or bestiality. Option C, in case of adultery coupled with such cruelty as without adultery would have entitled her to a divorce, a mensa et thoro. Option D, in the case of adultery coupled with desertion without reasonable excuse for 2 years or more.
Which one is odd man out, not connected with the where she can approach for the divorce?
A is correct, sir. A is odd man
Sir,
out.
option B, sir.
Option A is odd man out.
Is not
Option
connected.
B, sir.
Is it not connected to get the divorce? I'm speaking about the wife's side getting the divorce on the grounds of the husband.
A is wrong. A is odd man out, sir. Woman to woman, na? Another woman.
Petition by wife.
So in case of marriage with another woman, with adultery, how is it possible?
Man will with the another woman. Is the man committing all this activity?
Here, wife is filing the case, sir. That she is option A is husband is married another woman.
Yes, that is obvious. Husband is married with another woman. It's a ground for the divorce. If the husband made a rape or sodomy with the bestiality with another woman, but
Petition
here,
filed by the wife.
see, wife making the petition against the husband. Did you answer? Did you get my point? Wife is making petition for getting the
Divorce petition.
divorce
Solution.
or legal separation. Here you cannot make it out because you don't know what is meant by mensa et toro or mensa et toro. You don't know. So here I wrote the mensa et toro is a different. Actually, the mensa et toro is the right answer. Means a divorce mensa et toro is rather a separation of the parties of act of law than a dissolution of marriage. In case of adultery coupled with the cruelty, and without adultery would have entitled her to divorce a mensa et toro. That is the wording they used. But I changed it mensa et toro, I made THRO. So actually it is a mensa et toro. That means she is not relevant. Is the wrong one. Is it clear?
Okay, sir.
Yes, sir.
Yeah, 50th question. Dismissal of the petition. The court will dismiss the petition for any of the following cases. Which one is the wrong option among the four options? Dismissal. A. In the case of evidence for any petition is not satisfied by the court or the petitioner's case has not been proved. B. If the court is not satisfied that the alleged adultery has been committed, find that the petitioner has during the marriage been accessory to or conniving at this going through of the said form of marriage or the adultery of the other party to the marriage or has condoned the adultery complained of. C. If the petition is prosecuted in conspiracy with either of the respondent and any of the said cases, the court will dismiss the petition. D. If the petition is prosecuted in collusion with either of the respondents and any of the said cases, the court will dismiss the petition. Among the
Option
A, B,
B.
C, D, which one is not connected? Means wrong. Which is
Option
the
B.
wrong option?
Option B.
WRONG.
Option C.
If I say
Option B
option C is the
right,
wrong, why it is wrong?
D is right, sir.
D is right, I know it. Why C is wrong? See, here I wrote collusion, but here I wrote conspiracy.
Yes, sir. Conspiracy collusion.
So, in the act, it is the collusion is there, conspiracy is not there. So, right answer, wrong, right answer, that is wrong answer for the 50th question is
C.
C. C is the correct answer among the wrong answers of the 50th question. Is it clear? సార్ మీరు చెప్పేది ఎట్లుందంటే నెవర్ ట్రబుల్ యువర్ సెల్ఫ్ టిల్ ద ట్రబుల్ ట్రబుల్స్ యూ. Did you get my point?
Yes, sir.
Okay, now 51 question. As per dash of the act, couples have to serve a notice with the relevant documents in the marriage officer 30 days before the intended date of marriage under the Special Marriage Act?
Option A, section 4.
A. Which section says?
Option A, section 4.
Section 5, sir.
Right answer is section 5B
5.
under the Special Marriage Act. Supplementary question. Special Marriage Act year
1956, sir.
WRONG
86.
1954, sir.
right. What is the act number? Supplementary question.
15, sir.
Are you sure? I
Yes, sir.
have the act with me. I will show you now. 52nd question. Marriage in India can be registered under respective personal laws. Hindu Marriage Act 1955, Muslim Marriage Act 1954, and Special Marriage Act dash. Just now I told you. You told me. It is
1954.
54 is the answer. Special Marriage Act. 53 question. I would like to see how many people will give the answer for this question. Anyone can unmute and read in loud voice.
Which is not the case law connected with the Special Marriage Act under the following cases. Mrs. Jardhan Dirdia versus S.S. Chopra. Srimati Saroj Rani versus Subramaniam Kumar
Sudarshan Kumar.
Chadda. Sudarshan Kumar Chadda. C. Renauld Rajamani and others versus Woman of India and
Union of
others.
India and another.
D. Rajneesh versus Neha.
Which is not
He is
the
right
case
answer,
law connected with the Special Marriage Act under the following.
A is right answer.
C, answer C.
Dinde versus SS Chopra.
Number A is very much relevant to the Special Marriage Act. B. Srimati Saroj Rani versus Sudarshan Kumar Chadda, very much relevant with the Special Marriage Act. Rajneesh versus Neha is very much relevant to the Special Marriage Act.
Renauld Rajkumar.
Then which is the right answer?
Then
D
C.
is right answer, sir.
Renault, Rajmani and other versus Union of India and another is not connected with the Special Marriage Act because it is connected with the conjugal rights, not Special Marriage Act. I thought of keeping here T. Sarita versus another case law, state of AP, that is Subbaya case law. But I know that you definitely will give it answer. T. Sarita versus Subbaya case law, if I keep it here, I'm sure that you are going to get the. Yes, Lakshmi.
9 each hai.
మాట్లాడతాను అందరిగా దుర్దానా మ్యూట్. So I did not give the case law here because if I give the case law T. Sarita versus T. Venkata Subbaya, I am sure that everyone can give the answer because she is an actress.
Sir, we know it.
Are you following me?
Yes, sir.
Yes, sir.
Yes, sir.
Intentionally I have not given this case law here because you know that case law belongs to the conjugal rights. So these are the cases which I framed today, and the cases which you have in our hand, that is a Special Marriage Act. We can frame the as number of the cases as we can. So now you said, A. Venkat Reddy, you say Act number 15 you said. Now I would like to test you whether you are right or wrong. You are wrong. It is not Act number 15. It is Act number
43.
43.
Yes, sir.
See, a supplementary question, I did not keep it over there because of the time factor is concerned. It is not so easy to prepare 30 questions. You have to squeeze your brain and frame the questions. And questions in a such a way you did not or you could not read anywhere before. That way that you have to frame the questions by looking at it and by twisting it, and you have to frame it. And now, supplementary question. How many chapters are there in the Special Marriage Act? Sir, we want to scroll down, sir. We want to know that how many sections are there. See, here I have scrolled down already. How many sections are there?
51, sir.
How many
51.
schedules are there?
5.
5.
Five
How many
schedules.
chapters are there?
8
8.
chapters.
8.
See, I have given supplementary questions. Chapter 3, Chapter 4, Chapter 5, Chapter 6 deals with what? See, Chapter 5 deals with the restitution of conjugal rights and judicial separation. Chapter 6, nullity of marriage and divorce. And Chapter 4, consequences of the marriage under the Act. Chapter 3, registration of marriage celebrated in other forms. So, a question also can be framed in such a manner. Now, another supplementary question. In which chapter there are very few sections are there? Check it. In which chapter still 5 minutes are there? In which chapter very few sections are there? Chapter 1, 3 sections. Chapter 2, many. Chapter 4, 3, many, more than 4. Actually, 3 is the number, chapter 1. Then here, chapter 5, only 2 sections are there. Is it clear? And if
Yes.
you go to the chapter 8 now, so in which chapter there are only few sections now?
Chapter 5, sir.
5.
Chapter 5 is having very few sections. It is the supplementary questions. See, I am showing you how I frame the questions. And sometimes no, because it is a Special Marriage Act, what are the remedies available over there? Matrimonial remedies. You take any act. What are the matrimonial remedies? Number 1, divorce.
Restitution of conjugal rights.
Number 2, restriction of conjugal rights. Number 3, maintenance. Number 4, children's rights to take care of them. Are you following me?
Yes.
Yes, sir.
These all comes under matrimonial remedies. Even a dissolution, I mean divorce. Of course, we don't say divorce now. Now we can say dissolution of marriage. That is the wording they are using it. Now legal separation also will be given in the beginning. Later on, after 1 year, 2 years later, depending upon the act, they will give the divorce. In the beginning, they did. Restitution of conjugal rights under the Special Marriage Act. Which section says? Anyone? Under the Special Marriage Act. It's a matrimonial remedy.
Section 9, sir.
Wrong.
Sorry, section 10 is right answer, sir.
No, here I'm showing, here I highlighted here.
22, sir.
I highlighted here. So restitution of conjugal remedy is a section 22. I can ask like that also. Section 22 of the restitution of conjugal right comes under the which chapter of the Special Marriage Act of 1954? Then the answer is
5th
5.
chapter.
5. Can the Special Marriage Act have voidable marriage, void marriage, irregular marriage, illegal marriage?
Viable marriage.
It is having voidable marriage here. There is no irregular marriage. There is a void marriage is there. And voidable marriage is there. But no irregular marriage. Can you say illegal marriage? For illegal marriage, we can say void marriage only. Am I right?
Yes,
Yes,
sir.
sir.
So now the children, legitimacy of the children, whether children will be entitled to get the inheritance. Answer is
Yes,
in
Yes,
sir.
any
sir.
act, children
180 days.
are going to get inheritance. Of course, Muslim law, if you acknowledge, the father acknowledges that he is my son and nobody makes an objection, at that time it can be done. But strictly speaking, as per the Quran, adoption is not allowed in the Muslim law. Mutabanna, that is the wording they use it. Mutabanna is not there in adoption, is there in the Muslim law. So, if anybody gives inheritance without the objection of anybody, then court will not come to the risk. Court will not come and file a case against you unless somebody go and knock the door of a court. Is it clear?
Yes, sir.
Yes, sir.
See, court will not have that much time to see who is sleeping with whom, whether they are legal, whether illegal. Unless somebody goes to the court only, they will make such a thing. At that instance only, it will be known that yes, it is the so and so thing. So, I dealt family law. At any time, it can be stopped. What is the next?
Public interest litigation.
Public interest. सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।